this week, Comrade Mike Macnair from Divisional Central Committee of the CPGB will look at the Supreme Court's decision to rule that the legal definition of a woman should be based on biological sex. After Mike has spoken, we'll of course take questions and contributions from the floor. So Mike, I'd like to pass over to you, please, for your introduction.
So the title of my talk, Usurping the Legislative Power in the Interests of Tory Party and Tory Press Campaigning. And then the subtitle is the case name. For Women Scotland is a lobby group. I don't know where it gets the funds from to pursue, to spend £500,000 on two occasions in the UK in costs in two occasions in the UK Supreme Court. But evidently it does, has the funds. I'm going to start actually I have to apologise to comrades perhaps for the fact that some of this is going to be slightly technical law. I'm going to start in perhaps a slightly surprising place. In the 1970s, and Centrepoint. Tower block in Tottenham Court Road, near Tottenham Court Road Tube, which was put up and was consisted at the time mainly of office space. It's since been converted into flats, but at the time it had office space with some maisonettes above the office space. And it was left vacant because leaving it vacant gave rise to a saving on the rates, and at the same time the developer could speculate on the expected rise in property values. And the consequence of this was that in January 1974, it was squatted by homelessness campaigners. And the consequence of its being squatted by homelessness campaigners, and generally that this property being left vacant in the context of the housing crisis, which has not got significantly better since 1970s, was that Camden London Borough Council attempted to compulsory purchase the luxury maisonettes in Centrepoint for the purpose of using them to house the homeless under statutory powers which it had to compulsory purchase vacant property for the purposes of housing the homeless. This proposal, naturally enough, attracted a Tory press campaign, loony lefty council trying to expropriate luxury flats for housing the homeless, luxury maisonettes for housing the homeless. And we've got a edge of that on the fourth entry on the side of the fourth link on the side of this slide of the Hansard discussion of legislation which was being proposed to make it easier to expropriate vacant property for housing the homeless. And in due course, the legal owners attempt to in fact succeed in overthrowing this compulsory purchase order. Court of Appeal perfectly sensibly says, yes, it is legally permissible for local authorities to compulsory purchase flats or maisonettes which are above ground level, and moreover, if they need to compulsory purchase the access for water, electricity, sewage, etc. in order to do that, they can do that. That's 1976. That's a decision in the Court of Appeal which is politically embarrassing to the Conservative Party. And the House of Lords in April 1977 duly overthrows that decision. This is Sovmott's Investments against the Secretary of State for the Environment, and says that the local authority doesn't have the power to compulsory purchase the rights of access, what's called the easements for access to these maisonettes because they didn't exist, in essence, because they didn't exist before the compulsory purchase would have been posed. And therefore, the Conservative press campaign is right. The Camden Council was wasting time and money trying to compulsory purchase these flats. Um, and so this is success for the Conservative Party. It's bloody inconvenient, and it's such sufficiently inconvenient ruling that the Conservative government of Margaret Thatcher reverses it by statute for the purposes of compulsory purchase, the compulsory purchase aspect of it. Part 5 and Schedule 3 of the Acquisition of Land Act 1981 gives the local authority power to, among other things, acquire easements for property of this sort. The underlying rule, which the House of Lords had adopted in order to defeat the compulsory purchase order, has in consequence become controversial. And in Platt and Crouch in 2003, Kent and Kavanagh in 2006, Wood and Waddington in 2015, we get divergent views about whether, in essence, whether Sovmots in the House of Lords is dispositive, which is the view taken in Kent and Kavanagh, or whether it isn't, which is the view taken. They're all in the Court of Appeal, Platt and Crouch, Wood and Waddington. Now, normally, in terms of the effect of legal precedents, you would think that House of Lords decisions were binding on the Court of Appeal, so that Kent and Kavanagh should be right and Platt and Crouch and Wood and Waddington should be wrong. But in what the courts say is, well, in Sovmots, they didn't take proper account of a prior case back in the 1920s. Again, why that should overthrow the authority. The reality is that we can't say, or lawyers can't in their capacity as lawyers and can't in court say, that Sovmots was simply a decision to defeat the decision in the Court of Appeal with a view to avoiding embarrassment to the Conservative Party in its electoral campaigning and to the Conservative press in its campaigning against the Labour Party. And the consequence of that, it's a senseless, in terms of its practical implications, it's a senseless ruling, but it creates a level of uncertainty in the law subsequently because of this senseless ruling, whose only purpose is to protect the Conservative Party's electoral campaigning. Now we come to our present case, and I'm arguing in this presentation that this is the same sort of phenomenon. For Women Scotland Limited, as I said, lobby group, anti-trans, in essence, anti-trans lobby group against the Scottish ministers. Decision in the Court of Session Inner House, which is the equivalent of the Court of Appeal in England, by Lady Dorian, who is the Lord Justice Clerk, which is the senior member of the court, Lord Malcolm and Lord Pentland. They rejected the arguments of For Women Scotland, but their decision is reversed by the Supreme Court of the UK, consisting of Lord Reid, who is the senior judge of the UK Supreme Court, Lord Hodge, Lord Lloyd Jones, Lady Rose and Lady Simler. And the judgment is technically by Lord Hodge, Lady Rose, and sorry, it should be Lady Simler, that's me, typo, with whom Lord Reid and Lord Lloyd Jones, without having actually contributed to the judgment, just agree with it. Just a quick flag sideways on who these people are. they're all, apart from Lord Reed, people who were appointed to the Supreme Court by the Conservative administrations between 2010 and 2025. In terms of their backgrounds, Lord Hodge, after going to the Scots Bar in 1980, Cambridge and Edinburgh, and then going to the Scots Bar in 1983, was a civil service lawyer. Then in 2005, by the Blair administration, appointed to the Scottish Court of Session, with a special responsibility for Exchequer, which in the Court of Session means primarily commercial and corporate cases, because it's stuff which is subject to UK law rather than just to Scots law. He's Kirk of Scotland, and chaired the Kirk of Scotland Commission in 2009-11 on same-sex relationships and the ministry. Lord Lloyd Jones, MA and LLB, which is a master's in Cambridge, and went to the bar, qualified for the bar in 1975, but was then a law fellow at Downing College, Cambridge, working chiefly on public international law and private international law. Then went to the bar, went into practice in 1991, part-time judge from 1994, High Court from 2005, Court of Appeal 2012, UK, Supreme Court 2017. Lady Rose is younger, bar in BA Cambridge, BCL, which is a master's in Oxford, bar in 1984, then worked for the government legal service successively in the Treasury and the Ministry of Defence, and as counsel to the Speaker of the House of Commons, part-time judicial roles to 2013, then judge at the Chancery Division, Court of Appeal 2019, UK Supreme Court 2021. Lady Simler, BA Cambridge, went to the bar in 1987, became, among other things, junior counsel to the Inland Revenue, part-time judicial roles, and then High Court 2013. So, as I said, most of these people, they're Conservative appointees. It's also the case they're all people with a record of working for the civil service. There's a sort of government type. It says something about the nature of the judicial appointments which have been made by the Conservative Party, that they're Conservative governments, that they're not, as a whole, in general, people involved in equalities. Similar is, it has been involved in equalities law, but the others are not generally people who've been involved in equalities law or public law, but in international and private law. The issue litigated, what we're concerned with is Gender Representation on Public Boards Scotland Act 2018. So it's a Scots Act of Parliament, which says that public boards, which is sort of quangos of one sort and another in Scots local government, and Scots national government and local government, should have a gender representation objective with the aim that 50% of non-executive members of the boards should be women. In the first set of litigation, the Scots government was connected with the Scots government's Gender Recognition Act, which was struck down by the Supreme Court a while back. But having lost, the Scots government has then given guidance that there is no definition of woman in the Act. Therefore, woman has the meaning under Section 11 and Section 212 of the Equality Act, with it, but in addition, Gender Recognition Act 2004. So this is not the controversial Scots legislation. if there's a full gender recognition certificate has been issued to a person, their acquired gender is female, the person's sex is that of a woman, and where a full gender recognition certificate has been issued to a person, their acquired gender is male, the person's sex becomes a man. And the question is a very narrow question. Is this guidance for the purpose of a 50% women rule for public bodies legal? Is it valid? And I add to the point, is this who is it who has a full gender recognition certificate under the 2004 Act? They have to have been diagnosed with gender dysphoria, medically diagnosed with gender dysphoria, to have lived in the acquired gender for 2 years immediately before applying, to intend to live in that gender until death, and provided a statutory declaration that there's nothing in their marriage status which is an obstacle to them having a gender recognition certificate. So it's not by any means, and indeed the reason why the Scottish Gender Recognition Act and the proposals which were originally made by Theresa May to make gender recognition easy is it bloody difficult, seriously difficult to get a gender recognition certificate. And we are talking primarily about post-operative transsexuals. Okay. Now we come to the Court of Session. The decision in the Court of Session, in essence, is that the nature of the Gender Recognition Act, the way in which the Gender Recognition Act 2004 is drafted, reference to sex cannot mean simply a reference to biological determinants. And then they go on to discuss at considerable length the point, which is the conclusion, in essence, their conclusion, that the word, quote, woman, in the context of the Gender Recognition Act and the Equalities Act read together, Equalities Act 2010 read together, has different meanings depending on the particular context. So that trans women can be women for some purposes, and at the same time not be women for other purposes. And those different purposes essentially reflect the judgments which were made by Parliament. I make this point important because it's an important one, that Parliament, having said in the Gender Recognition Act that where there's a gender recognition certificate, the person's sex is taken to be that of the acquired sex, then produces a series of specific carve-outs in relation to, for example, service in the armed forces, prison, etc., etc., etc. We know we may disagree, and it may well be the case that we disagree with the choices which were actually made in 2004 in relation to carve-outs, but prima facie the point about these is that these are choices which were made in the legislation on the basis of extensive discussion and so on. And so the Court of Session's judgment looks on the face of it to be just straightforwardly that that's the right answer from the point of view of a court loyally applying statute law. Now we come to the UK Supreme Court. And at paragraph 265, which is not the final paragraph in the judgment, the court makes the point, we are aware that this is a long judgment. 88 pages of PDF. I've took the HTML version and reduced it to 10-point type and 3-point gaps between sections, and it still comes out at 37 pages. Actually 9-point type for the quotations. This length buries the argument, makes it really difficult to get a hold of what the court is arguing, because it buries all the argument on the core question in a mass of narrative history whose purpose is merely rhetorical, to surround what they're saying with a mass of narrative history which offers a rhetoric in support of their conclusion. And then the central operative points. First operative point, the word woman has to have one meaning throughout the statute. It can't be said that it has different meanings for different purposes, having regard to the carve-outs and so the general principle and the carve-outs. Secondly, that meaning is biological sex. And thirdly, there are only two sexes. And secondly, in connection with this is stuff which is actually frames at the beginning of the judgment and at the end of the judgment, frames this argument, is argument about how courts interpret statutes and should interpret statutes, and arguments in which the court is, in my opinion, using reasoning which is only appropriate to a legislator, and which would be appropriate reasoning in a discussion in Parliament, but is not appropriate reasoning for a discussion in court. So we start with the first operative point, that there's only one meaning, and the justification is for saying that the legislator has to be taken to be achieving a coherent meaning, and that this coherent meaning is the way of sort of ensuring coherent, stable and workable outcome, an approach to the meaning of statute that is constant and predictable. This will be achieved if the legislation is construed according to the ordinary meaning of the words used. This is a quote from a prior case, but it's endorsed in this present case. Whenever judges say this is the ordinary meaning or the ordinary natural meaning, this is not quite I reach for my machine gun territory, but it's a territory where we should assume that the judges are about to make an arbitrary and unsatisfactorily reasoned decision. Because if you get to a senior court, ex hypothesi, and we've got 5 judges sitting in the UK Supreme Court, but 4 judges, the Lord Ordinary, who is the judge at first instance in the Court of Session below, and the 3 judges of the Inner House, the Court of Appeal, have decided the other way. So what the ordinary natural meaning of this word is precisely controversial, debated, not obvious, straightforward, and therefore the best way to achieve coherence. Secondly, this meaning is to be biological. And I've got a series of extracts showing paragraph 158, paragraph 164, paragraph 171, particularly paragraph 164. There is no reason to suppose that Parliament intended to introduce a change of substance from Sex Discrimination Act 1975 by introducing a modification to the meaning of sex in accordance with section 9.1 of the Gender Recognition Act 2004. Well, actually, normally we would expect that the GRA 2004 did modify, normal legal reasoning, we would expect that the GRA 2004 did modify the Sex Discrimination Act 1975. And then the definition of sex makes clear that the concept of sex is binary. A person is either a woman or a man. I observe on this that this is biologically untrue. There are a significant class of people who are biologically intersex, And the unwillingness to make any reference to the fact that there is a significant class of people that are biologically intersex tells us that what these guys are actually doing is attempting to legislate the doctrine in Genesis that male and female created he them. Although the word biological in 171 does not appear in this definition, the ordinary meaning of those plain and unambiguous words corresponds with the biological characteristics that make an individual a man or a woman. Again, ordinary meaning, plain and unambiguous words. This is typical rhetorical exercise in order to enable a court to make a dodgy decision. There's a pair of articles from the 1970s in the Modern Law Review about the 1980s in the Modern Law Review about the Thatcher government's appointments in judicial appointments in the House of Lords, as then was, called After the Ancien Regime, which pointed to this sort of practice of saying it's the ordinary, natural, it's obvious, etc., as a way of dodging careful reasoning. Secondly, only two sexes. I've already referred to that, but I add to it that only two sexes is absolutely fundamental to these guys, the argument in the UK Supreme Court. Okay, so that's the operative part of the argument. The word woman has to be used with the same sense all the way across the Equalities Act 2010. That sense is biological, and all persons for that biological purpose are either men or women. There's no such thing as intersex people. Leave aside whether the question whether trans women are women for what purpose, etc. The question of trans men being men is not posed by this because basically because there isn't significant discrimination against men tackled by the Equalities Act 2010. Okay, so then we come to backing this up. And on backing this stuff up, what we have is arguments about how the court interprets acts of parliament. And I'm going to put interprets in quote marks because it seems to me this goes quite some way from what one would ordinarily call interpretation. Firstly, the court says at 81 and at paragraph 81 and at paragraph 104 that we're not going to use the explanatory notes. The explanatory notes in the Gender Recognition Act 2004 do say that the sex, the legal sex of a person who has a full gender recognition certificate is changed. If the explanatory notes had said the legal sex of the person who has a full gender recognition certificate will not be changed, but there will be a new category of whatevers, then it's unlikely that the legislation in that form would have passed Parliament, partly because the point of the bloody legislation in 2004 was to avoid the UK having to continually pay out damages to trans men and trans women in the European Court of Human Rights, because the Court of Human Rights had held that the UK had to pay out damages to trans men and trans women whose acquired gender was not recognised by UK law. And the House of Lords had decided that this couldn't be dealt with at a judicial level. There had to be legislation. So we have, incidentally, in this case, The Guardian has reported on April the 18th that the woman who was the Deputy Director for Discrimination Law at the Equalities Office and the lead official for the Equalities Act 2010 says the exact opposite, that the intention of Parliament, as far as it's known from the what's called the travaux préparatoires, the discussions in Parliament and the preparation for the Act, was indeed to recognise for some purposes the acquired sex as the legal sex. So the proposition that we can't use the explanatory notes, there are to's and fro's about can't we use the explanatory notes, but the explanatory notes, it seems to me, are published, and they're published to the members of Parliament who vote. And it's in the same way as actually it has been said that if the government minister says to Parliament, this is the effect of this section, it's not consistent for the government to be allowed to argue the contrary of that in court, because they've persuaded Parliament to vote for it on the basis of what they hold out the effect of the section to be. Secondly, we are interpreting. Statutory interpretation involves an objective assessment of the meaning. Now, not an objective assessment of the meaning which Parliament used, but an objective assessment of the meaning which, quote, a reasonable legislature would be seeking to convey in using the statutory words which are so considered. A reasonable legislature. What does a reasonable legislature mean? Famously, Lord Radcliffe in Davis and Fareham UDC. This is about contract terms. This is a case about contract terms and unexpected circumstances which change the effect of the contract. The point is being made is that it's actually not something which the parties have thought about. Ex hypothesize, because if the parties had thought about it, they might have said something about it, and they haven't said something about it. So it might seem, says Lord Radcliffe, that the parties have become so far disembodied spirits that their actual persons should be allowed to rest in peace. In their place, there arises the figure of the fair and reasonable man. And the spokesman of the fair and reasonable man, who represents, after all, no more than the anthropomorphic conception of justice, is and must be the court itself. The reasonable man means simply what the court thinks. So if we interpret acts of Parliament on the basis of what a reasonable Parliament must have be taken to have intended, it means what the Parliament must be taken to have intended if it agreed what the current members of the court think should be the case. And where we go now, I'm leaping back to 1686. And indeed, further back, Dr. Bonham's case in 1610. In some cases, the common law will control acts of Parliament and sometimes adjudge them to be utterly void. When an act of Parliament is against common right and reason, or repugnant or impossible to be performed, the common law will control it and adjudge that act to be void. This is Edward Coke. It's not Edward Coke as a reporter. He was Lord Chief Justice of Common Pleas at the time of this case, but as a reporter, it was notorious already to his contemporaries that he wrote down what he thought ought to be in the decision rather than what was actually in the decision. But he, nonetheless, because of his politics and history, Cook's reports became authoritative. So Godden and Hales is a collusive test case in which a friend of the government prosecutes Hales for Catholicism, for failing to swear the test oath against Roman Catholics holding military command. He's been appointed as a militia officer, and the king has given him a dispensation from the obligation to swear the test oath. Again, this case is decided exactly like Bonham's case on the basis of impossibility. Powis, Solicitor General for the defendant. This act, that is to say the Test Act, which required Catholics to swear the test oath, and well, officers, army officers to swear the test oath, and said that it couldn't be dispensed with, would entrench upon an inseparable branch of the King's prerogative, which no act can take it away. And the Lord Chief Justice Herbert, the kings of England were absolute sovereigns. The laws were the king's law. The king had the power to dispense with any of the laws of government as he saw necessity for it. He was the sole act judge of that necessity. No act of Parliament could take away that power. It's an example of something which is against common right and reason, repugnant or impossible to be performed. It's putting back to my earlier slide. The result is the statute becomes incoherent. There's no coherent statutory text because of the internal contradiction. Now, what happened after Godden and Hales is that King Billy came over with the Dutch fleet and army, and King James was chased out of the country, and the entire senior judiciary were arrested and jailed, except the ones who fled to France along with King James. And some of them died in jail. Some of them were released after some years. And Bill of Rights 1689, that the pretended power of dispensing with laws or the execution of laws by regal authority, as it hath been assumed and exercised of late, is illegal. So my point is that the nature of the reasoning which the Supreme Court adopts in order to get, in terms of statutory interpretation, to its conclusion is essentially the same sort of reasoning as the reasoning in Dr. Bonham's case and in Godden and Hales. It's a usurpation of the legislative power. And we go a little bit further on this. The judges are writing like legislatures. I give two examples of this. The first is that they cite in section 19, which is also paragraph 247, rather a long paragraph to be a single paragraph, but nonetheless it is, the Equalities and Human Rights Commission, quote, recognition of problems in their interpretation of sex as certificated sex. That is to say, actually, when the Conservative government leaned on the EHRC and got them to go along with the anti-trans campaign, the EHRC issued this, how shall I call it, one way or another, it's ambiguous text, but this ambiguous text is then read by the members of the Supreme Court as a reason for them to adopt the interpretation which they adopt. And given that the EHRC openly said, in fact, that dealing with the problems which they identify required legislation, for the Supreme Court to adopt this biological sex definition all across the board, one definition, biological sex, is precisely, and to do it on the basis of the recommendations of the EHRC, which are tentative ones, is precisely to legislate. And that's reflected in also in section 20, which is the point which Lord Sumption has made, that trans people are still protected from discrimination in other ways. And for example, the point is that we have existing law that the Equalities Act protects from discrimination people who are thought to be gay but aren't. If they're discriminated against because they're believed to be gay, that can nonetheless be discrimination on grounds of sexuality for the purposes of the Equalities Act. And so the idea, therefore, is that trans women can be protected from discrimination against women because they're believed to be women, although they aren't women. Again, this elaborate, and I said quite long, paragraph 248 to paragraph 263. Yeah. This is reasoning which would be appropriate for the legislature, appropriate for parliamentary discussion, but is not appropriate for judicial discussion of what is purports to be judicial discussion of the particular use of words in the relationship between the Equalities Act 2010 and the Gender Recognition Act 2004, and in particular the guidance which has been given by the Scottish ministers in connection with the meaning of the word woman in that context. So my point here, again, if it had been the case that the Court of Session's ruling had been upheld in the Supreme Court, which would have been the rational course of action, that is to say, trans women are women for some purposes, and they're certainly women for the certainly trans women who are post-operative trans women are women for the purposes of being discriminated against as women. And indeed, the court admits this in so far as it wants to give them a protection from being discriminated against as women on the basis that they're believed to be women, although they aren't women. Trans women are women for some purposes, trans men are men for some purposes, not for others. The decision of the Court of Session is broadly sound, but it would have been embarrassing to the Tory press and embarrassing to the Tory party if the decision of the Court of Session had been allowed to stand. So to resist this embarrassment to the Tory press and the Tory party, we get an extremely artificial piece of reasoning on the part of the UK Supreme Court. And this extremely artificial piece of reasoning in part of the UK Supreme Court involves the Supreme Court in asserting a prerogative right to overrule statute by way of, quote, interpretation, unquote, which is rests on reasoning of a sort which was condemned in the Revolution of 1688 and the Bill of Rights 1689. Okay, so this is almost all that I'm going to say. I'm just going to make two observations. The first is that both of which are about useful idiots of different sorts. Useful idiots one is the Communist Party of Britain and the Young Communist League, who have issued a statement welcoming the Supreme Court judgment. This materialist outcome, they say, corroborates our view that sex must mean biological sex for the purposes of the Act, and that any other interpretations would negate its single-sex statutory interpretations. You're great materialists, comrades. What about intersex people? But equally, what about, do you really think that post-operative trans women ought to be placed in men's prisons? Or that post-operative trans women ought to be forced to use men's public toilets? Or indeed that we should have, as we've got in the States, butch lesbians getting arrested using women's toilets for being, quote, looks as though they're really men. Are they trans? Are they trans? So as I say, this is useful idiots on the part of the CPB and the Young Communist League. Useful to the Conservative Party because they're defending what is in essence judicial action to promote Conservative Party electoral campaigning and Conservative press electoral campaigning. Useful idiots too is the part of the left which simply tails trans activists and explains the Supreme Court decision as, quote, transphobic. I think there's absolutely no reason to suppose that the members of the Supreme Court are phobic about trans people. They aren't. They're just party to a cynical, dishonest maneuver which was originated by political operatives around the Republican Party in 2017-18 to target trans people on the basis that trans people are a vulnerable minority who can be targeted as a way of performing a dog whistle. And this dog whistle operation is not, in fact, in favour of feminism. It's actually in favour of separate spaces, gender politics, and Kinderkirche Küche for women, as is reflected in the fact that the guys who promote this stuff are also promoting trad wives and surrendered women, and the Trump administration, which has been very vigorous in promoting this stuff, and indeed it's out of the Republican Party's electoral manipulation operators that this whole campaign has begun in 2017-18. Yeah. Also, the guys who say that Andrew Tate should be free, that Andrew Tate is although on bail for alleged sexual assaults, is allowed to go to the United States for the benefit of their campaign. This is useful idiots. That's useful idiots like the Morning Star guys, useful idiots for. But the other side of this, the people are useful idiots in different way because they imagine that this is about transphobia and that the slogan is, quote, trans women are women. Well, actually, no. Trans women are women for some purposes. There are other purposes. So, for example, trans women, Yasmin raised this with us in discussion in PCC, but I have written about it before in an article on this topic. Trans women are much less likely to get breast cancer than cis women. Surprise, surprise. Trans men are much less likely to get prostate cancer than cis men. Again, surprise, surprise. It's not terribly surprising. It's not total, because cis men can get breast cancer and cis women can get prostate cancer. It's just extremely unusual. So it does matter. And there are a whole load of other areas where medical treatment, it's not the case that, quote, trans women are women, trans men are men, as an absolute general point. And then the consequence of attempting to maintain that position and of explaining all this stuff in terms of superficial ideological phenomena, of phobias and of bigotry rather than cynical political manipulation, is to put the revolutionary left, because I've got anti-capitalist resistance, RS21 and workers' power as all of examples of this, to just line them up behind trans activists who were committed to the Clintonista model of the coalition of the minorities through intersectionality with the intersectional unity of all the minorities with Wall Street. And the result of that, as we've seen, we saw in 2016 vote Clinton get Trump, and we saw last year vote Harris get Trump. You actually get the opposite of what you're seeking. And the inability of the tailist left to offer an alternative to that politics is fundamentally a real fundamental trap. So that's all I'm going to say. Bob, anybody who says that a person who has a gender recognition certificate will be protected is wrong, because the court is explicit that it rejects the interpretation of the Court of Session that a gender recognition certificate can change biological sex. Yeah. Uh, um, it's also true, it is of course also true that only a small proportion of trans people have actually got a gender recognition certificate. I think if anywhere is going to happen in terms of the legislation, it's going to be, if anything, to narrow the scope of the gender recognition certificate. And because it's not present in the current regime, that there has to be an operation, that you have to have had top surgery or bottom surgery, as the case may be, or both. You know? And the if you the point being simply that if you actually treat people who have got breasts and a vagina, albeit surgically constructed, as being quote men for the purpose of public facilities and so on and so forth, that really is, I think it's going to be extraordinarily difficult to defend. But on the other hand, saying that people who want to have to change their sex aren't covered is going to be because of the stuff. And it is true that there are, there's a small number of fraudulent people. There are some fraudulent people, there's a small number of fraudulent people. It's sort of complicated. I wrote about this in the first article I wrote about this, that the problem in essence is that about 4% of population are psychopaths, and only about 0.2% of people are actually trans. Yeah. Sociopaths, sorry, not psychopaths, sociopaths. So these people in sex offenders who are saying I'm trans and I want to go to a women's prison, which is actually there's existing legislation to carve out legislation which stops that happening. It's very small numbers, but it's still not marginal compared to the number of people who are trans. Yeah, that's the problem about it. There's a problem. It is a problem. Okay. But anyhow, the point being, the nature of this judicial ruling is that it actually demolishes the 2004 Act, and the narrow gender recognition certificate of 2004 ceases to be functional. It's not another ruling on the Scottish Parliament's plan for more widely available gender recognition certificates. Second point is, can they appeal? The answer is as long as the UK is party to the European Convention on Human Rights, an action will lie in the European Court of Human Rights in Strasbourg against the UK for damages for failing to provide gender recognition, gender recognition. And the part of the reason why the 2004 Act was drafted in the way in which it is, that it isn't just people who've had the operation, is because the European Court of Human Rights also had said between 2002 2004 that people who hadn't had the operation are also have a claim. Yeah. So this is if we were to read, we could read the decision in the UK Supreme Court as extremely narrow and say 99% of what's in this judgment is irrelevant. It's obiter dicta, things said along the way. And all it's concerned with is the meaning of, quote, woman for the purposes of the Scottish Act of 2018, which says that there have to be 50% women on public boards. Now, But at the same time, I don't think that isn't the way in which the court has said it, and it isn't the way in which the parties have said responded to it. It's the way the press has responded to it. Yeah. Um, but is it what will the UK has been running a campaign, or a lot UK lawyers have been running a campaign to say that the Convention on Human Rights was drafted by Catholics and should be read within the framework of Catholic social teaching, and therefore this is an European equivalent of American originalism, and therefore should not protect women's rights beyond a certain, should not protect trans rights, should not protect lesbians and gays and so on and so forth, because the guys who drafted it were proponents of Catholic social teaching, and that's the interpretation which has to be given to it. The other alternative is that the Conservative Party is now more or less committed to withdrawing from the convention. And the likelihood of that happening is now actually fairly significant, because actually basically because the Court of Human Rights in Strasbourg has made decisions adverse to the UK on immigration questions. And so even the Labour Party is now thinking about withdrawing from the convention, and the embarrassment of becoming the only European country other than Belarus and the Russian Republic to be not signed up to the convention is sort of, it's a real embarrassment, but perhaps not such a big thing. Okay. Tina, I've referred to, okay, EHRC, this is the Equalities and Human Rights Commission. It's Tory controlled. It's a quango. Faulkner, who's the chair of it, is a Tory. It's basically Tory controlled unless the Labour Party decided to purge it, which the Tory government did. Quite a lot of these quangos are Tory controlled because the Tories have been in control of appointments since 2010. Yeah. What will it is possible. The problem is it possible to overrule the judiciary on this question? Well, yes, if you're prepared to do what they did in 1688. That is, throw the lot of them in jail on the basis that their decision is usurpation of the legislative power. That their decision that their decision is illegal, because otherwise it without actual, and we have had more recently, slightly more recently than that, the Lord Chancellor was impeached in 1724 and fined some inordinate sum of money and sacked. Judicial impeachment has sort of gone out. It's not restricted in the way in which it is in the US, because you only need a simple majority in the House of Lords to succeed in impeachment. But at the same time, without actually sanctions against the judiciary, it doesn't matter what form of words you use, the judiciary will find a way around it. Okay, Tina's point. What positive alternatives? I think that in the first place, actually, the defense of the Court of Session's position, trans women are women for some purposes, but not for all purposes, is fundamentally correct. Secondly, we have to actually positively campaign for gender neutral facilities and gender neutral toilets. This is okay. There's a sort of women saying, "Oh, gender neutral toilets, the men will stand up to piss and there'll be piss on the floor and stuff like that." But the reality is, you live with, heterosexual couples live with that in everyday life in their homes. And if we ask the question, why are there men's toilets and women's toilets? The answer is that the Conservative Party in the 19th century and its equivalents in the United States in the 19th century thought that there should be fewer toilets for women than toilets for men, because women should stay at home. A fatuous argument, and one which depended entirely on a perspective of middle-class women staying at home and their servants going out to shop and stuff like that. But it's clear that that was the basis of it, and it's clear that the consequence of it is that there are, in fact, many, 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 many fewer women's toilets than men's toilets, and public toilets, that is. There's been a cut in the number of public toilets available as a result of cuts in local government expenditure over the last 40, 50 years. So we should be campaigning for equality of access to toilets, that is to say, many, many more unisex toilets. We should be campaigning for the abolition of state requirements of that you have to say male or female. Because the problem about it's all very well saying male or female, and if I get a gender recognition certificate, I transition to my true person. But there's a whole lot of people. It's not just that there's intersex people, and intersex people are actually violated with surgical treatment in infancy to try and make them appear more male or more female, as the case may be. Yeah. It's not just that there's intersex people, it's also there's a whole lot of people who don't want to be, who want to say, I'm non-binary. Mm-hmm. And gender recognition is actually useless for these people. Mm-hmm. In relation to jail, CPGB has had the position in our draft programme. I forgot to put it in the trans articles I wrote, but it's an important issue, that we should be making much, much, much less use of jailing people. And then the question of trans people going into the wrong jail becomes a very much marginal question. Mm. Ben, I've sent on to the chat there's two clauses: the dispensing power and the suspending power and the dispensing power. And the suspending power is just declared to be altogether illegal. The dispensing power is declared to be illegal as it hath of late been exercised. The reason for that is because giving property to a church or charity under the Statute of Mortmain 1279 was completely void, and the feudal superior was entitled to enter. And the Crown provided a licensing system under prerogative, under which you had to check that it wasn't prejudicial to anybody and pay for a license, and cost an awful lot, to alienate land to a church or charity. And okay, they could have abolished the dispensing power altogether, but in order to do that, they'd have to have legislated away the Statute of Mortmain and all the other provisions which the dispensing power was used to deal with. It was still the case. My former employers had in the charter of the college a prerogative license to acquire land in Mortmain to the extent of £100,000. Not a whole lot of use at the present date, but that was 1921 when the college was founded. It was only 1960 that the Mortmain rules were abolished. Yeah. So it's the point is whether they should have been is another question as well, but leave that aside. My point is simply there's a whole load of things which we can raise as demands in relation to the situation of trans people. It's just that it's not the sort of approach to it which is the approach of the tailist left. That's it. Ant made the point, and I think it's not a bad one, but it's a sort of, it's not a bad one, but it's not a good one as well. that, and somebody else made the point in the chat as well, that what I had to say was too narrowly focused on what this court had done. You know? And what I addressed it to, in fact, was the constitutional significance of what this court had done. You know? And secondly, to the fact that it's a wonderful demonstration of the fact that the court, as a court, pursues the interests of the Conservative Party, not of the interests of capital in general. Yeah? And the same is true of the Centrepoint case. Yeah? The Centrepoint decision is not a decision in the interests of capital in general. It's a decision in the interests of the electoral interests of the Conservative Party. And in the same way, this decision this year, this is a decision in the electoral interests of the Conservative Party. Okay, so narrowly, then moving out from the narrow, I referred to issues which we can raise as immediate issues in relation to the legalities. I think there are also issues which we can raise as immediate issues, which are sort of ant-related issues in a sense, because, as he says, in essence, what we've got is a regime, and it's a regime which was created in 14th century Italy, 16th to 17th century Netherlands and England, which discriminates between the deserving poor on the one hand and the undeserving poor on the other hand, and which attempts to create a regime of, quote, less eligibility for the undeserving poor. And by creating a regime of less eligibility for the, quote, undeserving poor, to force people into sweatshops and other forms of super exploitative labor. That's that regime, because it's discriminating between the deserving and the undeserving poor. One of the consequences of it, aspects of it, is that it treats sexual deviance, not only sexual deviance, as prima facie, equally it treats single mothers as prima facie undeserving poor. Now, these are a whole load of things where, and there's a nice book, woman Colleen Lewis wrote a book called Everybody, Politics of Everybody. And there's another the point is that trans people coming from a middle class background, because they seek to transition, are unexpectedly thrown into the ranks of the undeserving poor. That was true of gay men and lesbians down to the 1980s. High proportion of people wound up in precarious forms of labour, excluded from this. At the same time, however, actually, the introduction, the generalisation of precarity, that the layer of people who are not in precarious conditions of labour is now really quite narrow. And in the same way, trans people, a lot of trans people raise, and quite rightly, that they don't get access to, so it's very difficult to get access to surgery. It's very difficult to get access to hormones unless you've got the funds to be able to go on the black market, unquote, the informal sector, or go abroad. A friend of my daughter's, this is 10, 15 years ago, 20 odd years ago now, went abroad for the operation. It's but there's two aspects to this. Aspect one of this is that doctors pursue Christianist or other socially conservative agendas and use their position as doctors to ration access in ideological ways. And we can see that also, actually, it's more brutal in a sense, the surgical interventions to get rid of sex ambiguity in infants. Jesus Christ. But equally, actually, um, is part of, we legalized female circumcision. But it's actually male circumcision is also the case. It originated, it was proposed in the 19th century as a prophylactic against masturbation. Yeah. And continues to this day in the United States as routinely um, circumcising male infants without anesthetic, because the doctors who perform this think that babies don't feel pain. What the fuck? Yeah. This sort of uh, ideological, and there was some really weird stuff. I was reading a book about this stuff, that some astonishing forms of intervention in the 19th century with cutting off part of the digestive system on the basis that this would increase purity. What the fuck? Surgical madness of, but at the same time, besides the stuff of surgical, there's also just the NHS is under-resourced. There isn't enough. The United States has this awful insurance-based system with people can be rendered bankrupt, etc. So there's a whole raft of things that, in my opinion, I don't think that we wouldn't be appropriate for us to add that question of access to medical services to the draft program in relation to trans people, because it's something for everyone. It's everyone is affected by the Conservative Party's campaign to get rid of the NHS and go over to American style system. Okay, the trans people are specifically affected by doctors using rationing access to surgery for ideological reasons. But actually, women are also, there's quite a lot of stuff which is of women having had their vaginas, quote, surgically reconstructed, unquote, after childbirth, because the doctors think that will be better from the point of view of sexual pleasure for men. And some of the stuff which has been used for this has then turns out to be bad, goes bad, doesn't work, etc. So it's just that sense of that Ant is correct, that quite a lot of these things are things which are not just about trans people, but about trans people and gay men and lesbians and women and the poor in general and people in general. Mm-hmm. So there are things which we can the things which we can and must pose as part of the quote minimum program as things which we could do. So we could get rid of the requirement to specify gender on birth certificates instantaneously. Requirement to specify gender on official documents. We could do that very straightforwardly. On the other hand, overcoming the problems of rationing in the National Health Service, that's not just a matter of taking power, it's also a matter of seriously reorienting production so that it is we get production for the sake of running an effective health service and providing what people need, and so on and so forth. Jack was absolutely right as against, and in respect of the capitalist class is completely cynical about these questions. Mm-hmm. And just as much true, it's a point that Engels made in Condition of the Working Class in England, that the capitalism, when it suits it, liquidates the family, forces workers to live, sends the infants into the factories, forces workers to live in barracks. We've got that in South Africa, for that matter, the apartheid regime radically separated men sent off to work in barracks. It, or for that matter, how familial was the regime under which the City of London sold 7 and 8-year-old orphans to Arkwright to be, quote, apprentices working in his mills, or the uh, um, numerous people who were transported overseas to the American colonies, or the African slaves who were taken, and so on and so on and so forth. Capitalism is cynical about these questions. Capitalism exploits, and we have actually capitalism throws up both liberalism, which is the ideological reflection of market society and the freedom of choice which exists in markets, and it throws up um, authoritarianism, which reflects the nature of the factory. There can be no capitalism without the collective the collective subordination of groups of workers, even if it's only in docks and sailing ships and stuff like that, or for that matter, the building trade, the Confederacies of Masons Act 1425, which banned conspiracies of masons to raise wages, i.e., the first anti-union 1425, the first anti-union law, and it's in the building trade. Um, uh, uh, so we have to have, in that sense, we need both. Jack is right. We need the minimum program in terms of what could be instantly done, and operate as counter to immediate institutions of capitalist rule, and we need the maximum program. It's not the idea that it's an example of the uselessness of transitional method and transitional demands. We need the idea of the general human emancipation, and the way in which general human emancipation involves getting radically beyond capitalism. And say, for example, secondly, one of the things which trans people are routinely affected by is queer bashing. Okay, again, queer bashing is a phenomenon which is not only of trans people, but also of gender non-conforming gay men and lesbians, but also actually it's all, in a sense, a side effect of um, uh, 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 the violence against women. And all of these things, violence against women, queer bashing of gender non-conformist gay men and lesbians, queer bashing of trans people, and in particular, actually, of trans men, are particularly vulnerable to being queer bashed and also to being prosecuted as frauds. You know? All of that is all forms of performance of competitive heterosexual masculinity, of the display of masculinity, which shows I'm a competitive big man. And that performance of competitive heterosexual masculinity is produced by the need to perform competitive heterosexual masculinity, is produced by the formation of sexual relationships in a sexual marketplace, which is something which capitalism, and we can, it's very visible that as capitalism develops in late medieval Italian city-states, in the Netherlands in the 16th, 17th century, in England and France in the 17th, 18th century, as capitalism develops, along with it develops sexual marketplaces. Along with the sexual marketplaces for heterosexuals, develops the subculture of sexual marketplaces for first for gay men, and then only much more recently in the 1880s, 1890s for lesbians. And these sexual marketplaces create this regime of competition. So this overcoming this regime of competition, and in consequence the regime of violence, which is a product of the regime of competition, um, involves not just the minimum program, not just the seizure of power, political power by the working class, but the actual transformation of the society in ways which it's actually rather difficult for us to predict, because in a sense the situation which we're in um, is like the uh, situation of the Democrats and Republicans after the collapse of the Italian city-states into tyranny, and between the collapse of the Italian city-states into tyranny and the emergence of Dutch and British capitalist regimes. The sort of couple of 100 years, but then it's as hard for us to predict what full socialism will look like as it would have been for these guys in the late 1400s to predict full 19th century, 20th century capitalism. Um, we have to go through that, recognize we need both of those elements. I'm going to, dear me. Oh, Jeffrey Vernon in the chat made what I thought was also quite a good point. We shouldn't imagine that radical trans is a fundamental challenge to bourgeois morality, because look at Stonewall as it was before. Yeah. But equally, I have this sort of personal, I have a personal history. I was involved in the gay liberation movement in the 1970s. Yeah. We thought, it was one of the slogans of the early gay liberation front. Hey, hey, what do you say? Try it once, you might be gay. Excuse me. It's an example of the situation, l'international situation, situationniste in Paris in 1968. Their slogan, "Sous les pavés, c'est la plage." Under the pavés, under the paved roads of Paris, is the beach. Yeah, immediate. This is cultural revolution. We can instantly transform. There's no gradual process, no gradual element, neither a gradual element before the overthrow of capitalism, nor a gradual element after the overthrow of capitalism. And then, in consequence, we imagine that homosexuality as such challenges capitalism. Pat Califia and her co-thinkers in Samoa in the 1980s argued that BDSM as such is a radical challenge to capitalism, because it caricatures, as a wonderful expression, there is a hard-on under the army uniform, under the priest's robes, and BDSM sexuality brings that into the open. But the reality is it's delusional. The idea that that's actually a challenge to capitalism. It's part of the old Maoist conception of from the periphery to the center, and the rejection of class politics on the ground that the working class is a labor aristocracy and utterly corrupted, and etc. etc. So yes, and has been chatting in the chat. But it's the same point. We will not resolve these things short of the development of. We will not resolve quite a lot of these things short of the development of communist society. But there are also things which we can resolve at the present moment, and also there are also choices which we can make which are lesser evils. So I don't I think want to say, as Rafal proposed, that we have to have one set of rules for sex and one set of rules for gender. I agree that we do need to recognize that biological sex is one thing and gender is a distinct thing. But actually, I think quite a lot of the rules which the anti-discrimination stuff in the Equalities Act 2010 is about creating privileged interlocutors, is about the idea that if there are 2% 5% rich people and 35% middle class people and 45, then there should also be 5% rich gay men and 35% middle class and 45%. It's this conception of the Equalities Act is designed round the conception of intersectional unity with the capitalist class. That's the structure of the definition. Okay, so we have to propose alternatives to that, but nonetheless, it's still the case that we can defend the greater rationality of the Court of Session and the fact that the Court of Session's decision is more consistent with the democratic decision of its semi-democratic decision of Parliament in 2004 and 2010 than the arbitrary Christianist pro-Tory agitator decision of the Supreme Court, UK Supreme Court. Just as we can decide, it's not the solution, but vote Labour where there's no better alternative than voting Labour, even under present circumstances. But that sort of lesser evil, or indeed the Bolsheviks in 1910 say, if at the end of the day the voting forces you to choose between the Cadets, the Constitutional Democrats, and the Octoberists, then you vote for the Cadets. That's without placing confidence in the Cadets, without forming a political bloc with the Cadets, without mixing the banners. And the same is true in relation to the Court of Session versus the Cadet Court of Session and the Octoberist UK Supreme Court. That's it.